Carpenter versus United States. The issue in this case is whether the police access to cell site location information should be considered a search. Cell site location information means when a person uses his cell phone would make constant contacts with the nearest tower so that the phone would have this better reception. And then this phone company would keep track of this information as to with which tower this particular phone actually has contact with. And then that way, if a police could have access to this information, police actually could track down this person's whereabouts. In this particular case, the defendant was involved in a series of robberies in 2 states. And then the police had access to this cell site location information, and this information indicated the defendant was close to the robbery site in several robberies. So that would be very powerful evidence against the defendant, because whenever there was a robbery and then his phone was just nearby, that means he was in participation of these robberies. And then the issue in the case, once again, was whether this police access to cell site location information should be considered a search. If that was considered a search, police would need probable cause and warrant to have access to this information. But in this case, police did not have a probable cause and they did not have a warrant to have access to this information because the police, there was a law indicating if police believe this cell site location information is necessary for ongoing criminal investigation, and then they could have access to this information. So the police just went to the court and just got this subpoena, and then they just got this information. So the requirement for this to subpoena this information was not police need a probable cause and to prove they have sufficient information indicating the defendant was involved in a crime, and then they want to have that information. That was not the requirement. So long as the police would indicate to the court this information was needed for ongoing criminal investigation, that was sufficient. So when the information was, when this cell site location information was used as evidence, and then the defendant appealed this use of this information, the defendant argued that was in violation of his Fourth Amendment right. So the court needed to determine whether this police access to this information should be considered a form of a search. It is important for us to take note of this. The ruling of the court was the access to cell site location information was a search. So in this case, based on this ruling, that means in the future, if a police want to have access to this cell site location information, they must have a probable cause. They also must obtain a warrant from the court before they could have access to this information. In this context, I think it is important for us to understand this. The court said if the police would have this free access to this cell site location information, and then they would be able to trace a person's whereabouts in great details, and the court said that would implicate a person's legitimate expectation of privacy. On this point, it is very important for us to understand this. A person's whereabouts or a person's movements in public places, that is not a matter of privacy. That means if you walk on the public street and if you drive on the highway, that this movement would not be a private matter, because anyone who wants to know this movement, that person could see that. So this a person's whereabouts or movements in public places should not be considered a private matter, or in other words, a person should not have this expectation of privacy about his movements or whereabouts in public places. For example, if a neighbor would be interested in the person's where the person would go, and then the neighbor could always follow the person, that would not, and then the person cannot really say, I have this expectation of privacy, I would not be followed, I would not be seen in the public. The person certainly cannot claim that kind of expectation of privacy. Similarly, if a police want to follow this person around, and if the police want to put this person under surveillance, and if a police would follow the person without the person's knowing that would also be permitted. But we need to understand, the police cannot do this kind of low-tech surveillance by following the person around on a constant basis, because that would consume too much police resources, and then they could not really do that in practice. And because of that, in practice, the police could not do that. But the court said, if now we allow the police to have this access to this cell site location information, this technology would allow the police to know in great details a person's whereabouts almost every minute. If a person went to a political rally, if a person went to a restaurant, if a person went to a religious practice, and then the police would be able to know everything about this person's movement, and without much efforts on the part of the police. So, and then the court said, if we would allow, if the police would want to have this kind of a detailed information about a person's movement, that would implicate the person's legitimate expectation of privacy. So that's why the court in this case held, if a police want to have access to this cell site location information, they must have probable cause. They must obtain a warrant from a judge before they could have access to this information. The next issue we want to discuss is police highway checkpoints. We have two cases, and one is Michigan Department of State Police versus SITS. And in this case, and the issue was the police set up these checkpoints for drunken drivers. And the police highway checkpoints for drunken drivers was permitted. The ruling of the court was these police highway checkpoints was constitutional. And then in the second case, that is this city of Indianapolis versus Edmond. And then in this case, the highway checkpoints were set up for detecting these illegal drugs. And then in this case, the court said these highway checkpoints were not permitted. To understand why, in one case, the court said these highway checkpoints was constitutional, and in another case, the court said these highway checkpoints were unconstitutional. We need to understand these important concepts. That is, maybe we can say, we need to understand this distinction between searches and seizures conducted for special needs and searches and seizures conducted for investigating an ordinary crime. In this Michigan case, why the court said this police highway checkpoints was constitutional, because that highway checkpoints was set up to accomplish a special need. That was to stop these drunk drivers. The court said this drunk driving was a serious problem, and every year many people actually died in this highway because of these highway accidents because of these drunk drivers. So these police highway checkpoints were set up to find these drunken drivers. So this the purpose of these police highway checkpoints was to ensure highway safety. The primary purpose of these highway checkpoints was not to investigate an ordinary crime. So the court said whenever there was a search or seizure that was conducted to accomplish these special needs, and then no probable cause and a warrant would be needed. And so these are highway checkpoints for drunken drivers, and we have some other examples the court actually discussed in that case. These are highway checkpoints for drunken drivers, or these are highway checkpoints for stopping illegal immigrants, or this random drug testing for students, athletes, or this random drug testing for U.S. customs officers seeking promotions. And for these kind of searches and seizures, the court said because the primary purpose of these searches and seizures were they were not to investigate these ordinary crimes. They were to accomplish this conducted for these special needs. So no probable cause or warrant would be needed. But when searches, when a search or seizure was conducted for investigating an ordinary crime, and then the ordinary Fourth Amendment requirements must be followed, meaning there must be probable cause, there must be a warrant. If there is no exception to cover this search, and then not only probable cause, but also a warrant would be needed. So these police highway checkpoints for stopping this illegal drug trafficking, that would be an example of police investigating ordinary crimes. So because this, in the second case, because these police highway checkpoints were set up for stopping this illegal drug trafficking, so the court said the police must follow this these normal Fourth Amendment requirements. That is, they must have probable cause, they must have a warrant before they could conduct these kind of searches and seizures. So it is important for us to make this distinction. The searches and seizures conducted for special needs and these searches and seizures conducted for investigating ordinary crimes. If the searches and seizures would be conducted for this investigating ordinary crimes, and then police would need probable cause and a warrant. So this, if these highway checkpoints were set up for this investigating ordinary crimes, and then the police also, they need to have probable cause. They need to have a warrant. They just could not just set up these highway checkpoints for this investigating an ordinary crime.